Thank you. We are back to hear our second matter of the morning, and that is, maybe someone can make sure that we pronounce this correctly from the get-go. State versus?
Groce.
Groce. Thank you. That's our case number 2024-0362. If we'll go ahead and take appearances from council.
Ann Talaferro for Mr. Groce. I can't pronounce my own name.
Thank you, Ms. Talaferro.
Sung Doucette for the state.
Say your last name again for me, please.
Doucette.
Ms. Doucette, thank you. Thank you both for your good briefing and for your preparation for today. We look forward to now engaging with you, and I think you're both familiar with the way we operate, and looks like, Ms. Talaferro, you've reserved 3 minutes.
Yes, Your Honor.
We'll go ahead and proceed.
May it please the court and counsel. It is supposed to be hard, really, really hard to keep somebody detained prior to trial and adjudication of a criminal offense. At this point in time, you're presumed innocent. You're not supposed to be held for months and months and months on an allegation on at most probable cause. That's not the way it's supposed to be, and it is our belief that that is exactly what has happened here. In this case, the court is holding Mr. Groce without bail on the following information that was presented at the detention hearing. 2 witnesses, a husband and a wife, a husband that was driving through a parking lot one day to find his own family, and a wife saw a man in a Tesla, parked in a parking lot by a park. The Tesla was backed in. They saw a man. It was in the light of day. There were other adults and other people around, and they saw this man in this Tesla wave at a child in a come here motion. The toddler, about 3-year-old child, had been in the park, appeared to this man to be walking towards the Tesla. The man never got out of his car. The man never said anything. He waved in this summoning come here motion. And the toddler...
Was the child headed that way anyway, or did she head that way in response to the gesture?
We do not know the answer to that. We don't know the answer to that. The witness says that he saw from his own vehicle that the toddler was moving in that direction. When the witness saw this gesture and the toddler moving, he became upset. He asked his wife, whose child is this? He then backed up his own car, and his wife moved towards the man in the Tesla. The man in the Tesla closed his door, moved away, and the witness man chased him away. Based upon that evidence, Mr. Groce was charged with attempted child kidnapping.
Ms. Talaferro,
Yes.
Isn't there additional evidence, though? He is a convicted child sex offender who's not supposed to be in that area, or at least if he's in that area, not beckoning to children.
Well, I mean, so that is true, but it goes into, okay, that is part of, I guess, the totality of the circumstances. When when the man chased him down, he got a partial license plate. Police officers identified Mr. Groce as the owner of this vehicle. He was found to be a compliant sex offender. He had a prior misdemeanor lewdness for sitting in a parking lot masturbating in a car. Based upon that totality of the evidence,
He was compliant until that day.
Okay, well, I mean, we can argue about that because,
Sure.
I mean, because
I guess I just want to put on,
No,
when
sure,
you say,
sure.
let's look at the totality
No,
of the
absolutely.
evidence, the other evidence is he fled. He didn't stick around and give an explanation for, this wasn't a police officer, it was just another parent. Isn't the fleeing also part of the totality that shows there may be malintent?
yes, malintent though, well, it can show malintent that he fled. It could also be that he was being chased by other people, right? But even if you're assuming malintent for some reason, you are speculating that it's malintent to kidnap a child. And I think that is why we have such a problem here, is because we have this basic set of facts that I believe everybody agrees on. But based upon this basic set of facts, they have to show, they charged him and he is being detained without bail.
Why couldn't a jury, you know, I take your point. You're making some really good points. A jury might well determine that the evidence doesn't add up to beyond a reasonable doubt for intent. But why couldn't a jury make the other call on this evidence? I mean, isn't this a sort of a quintessential jury question about what's going on in his head?
I don't believe so, because in order to, and we have to kind of get into the charge and what an attempt means and what a substantial step is and all of that. But to the court's question, I don't believe that sitting in a park, whether you're a sex offender or not, sitting in a parking lot, and we can fight about whether he was truly in a protected area. We've made indications that is not necessarily true. But sitting in a park, waving to a child, what that wave means is really up for anyone's guess, right?
Well, but the people who watched it
Right?
were concerned enough as they, you know, I don't want the word stranger has been thrown
No,
around in this case a
absolutely.
lot, but they were not affiliated with this little
Absolutely.
girl. And
Absolutely.
they watched this happen and they were concerned enough. They thought what was happening was an attempted child kidnapping. They took action to stop that. And so if this evidence causes bystanders to think that's what's going on, why couldn't a jury reach the same conclusion?
Because additional evidence, I guess, that was presented from the videos are the reasons that these bystanders believed, that they said that they really didn't know what the intent was, but in their interviews, and it was all in Spanish, and thank goodness my co-counsel at the time spoke Spanish, because she was able to watch the interviews with the police officers. And they had said something to the effect of, and this was presented at the detention hearing, something to the effect of, we didn't really know, you know, what his intent was. But from our country, you know, people, I don't want to say get kidnapped all the time, but this is more common, and so that is what caused us concern. I think that you have to look at the facts, and you can't speculate at this point. At this point, there was a wave. And at this point, state has to show substantial evidence that that was a substantial step to kidnap the child, and to show that this conduct, this wave, also corroborated an intent to kidnap. Now we have given the court and the district court 4 main cases on attempt and child kidnapping, concerning what it means to take a substantial step.
Yeah, so
Right.
let's take the Smith case.
Right.
So defendant shows up at Maverick, flashes his headlights as communication, that's essentially beckoning. I'm here, come out now. And the court said that was a substantial step. How's that different?
And I think it's very different, and I understand that the Court of Appeals and Your Honor dealt with the Smith case. In Smith, the question was, is this more than just, I guess, solicitation, right? So they were saying their fear was they didn't want to conflate solicitation with a substantial step. In the Smith case, it was a online chat kind of situation where initially the person made an agreement to meet this person, and the solicitation happened at the keyboard. In addition, the substantial step was he made an agreement to meet the person at this gas station in Lehigh. He went to that gas station in Lehigh. The intent was there because he was basically saying, yes, we're going to have sex, and I'm going to take you out of the country. So he goes to the gas station in Lehigh. He parks where they agreed to park. He sees the girl. He texts her. He says, stand in this place. When you see me flash my lights, come to me. And that's exactly what he did. So he took a series of additional actions that not only were a substantial step into committing the crime of attempted kidnapping, but he took a substantial step in conduct that verified what his intent was going to be. That is different in this case because we don't have any of that. We have a waive.
Right, but we're not worried about solicitation here because
Absolutely.
you can't solicit a 3-year-old.
Absolutely.
Right, so
Absolutely.
what's the, give me the opposite speculation. Why was he beckoning a 3-year-old to come over to his car as a sex offender?
He waived. He said, he didn't say anything.
What possible reason could he have for doing that?
To
other
say, to get the child's attention, to
Why?
say hi, to say coochie coo, to say whatever. Even if he wanted him to, even if this person wanted this child to walk towards his car, to talk to them, it doesn't go to the leap of attempting to kidnap a child.
Ms. Taliaferro, on this point, I think, I have a hard time seeing how it's not a substantial step for some untoward action. That we have a convicted sex offender who's not to be interacting with children, and he's now beckoning to a child. In my mind, that's a substantial step to do something bad. And that your better argument might be, we don't know exactly what bad thing he was taking a substantial step toward. Was it merely to have the child come closer and him be aroused as he talked to the child? Was it to again engage in lewdness? But both of those could be accomplished with the child at a distance. Is there any other untoward act than kidnapping that this could indicate, or would it be speculation as between a number of potentially bad things?
I think it would be speculation, A, that it would be a bad thing, and speculation that it could be a number of different bad things.
What other bad things would you put in the list?
Well, I don't want to get my client charged with a
Sure.
number of events, but this waive, I mean, in these cases, it could have been, I mean, it's just as much speculation if they would have charged him with rape of a child, right? Why is waving at the child, how is that intent, how is that any more, I don't know how to articulate this. It could be rape of a child, it could be a sex offense, it could be an attempt to kidnap, it could be to say hi to a child. It could be later on in the preliminary hearing, and I know that the state doesn't believe that any of that information should come to the court, but the preliminary hearing evidence was even better because we get the ins and outs of the where they allegedly viewed this wave from. So we are assuming for the detention purposes that this was really a wave come here, but everybody was 100% clear. They never heard him say anything. They saw him in his car. So we are speculating into what that wave means.
But to do any of those other bad things, he's got to put her in the car first, right?
Not necessarily.
To commit rape of a child, where's that going to happen? In front of these people on the hood of the car?
Perhaps.
I mean,
he's
Would there not be
waving.
detention?
He's waving to a child in broad daylight with people around, and everybody, because they found out he was a sex offender later, everybody jumps to the conclusion he is trying to kidnap this person.
let me ask a better question. If she had gotten in the car, there's evidence of kidnapping right there, right?
And sure.
Okay. And so she's on her way over to the car for some purpose. We don't know exactly what that purpose is. We have to draw inferences, and the jury would potentially get to draw those inferences. But you're sort of weighing what those potential purposes were. I mean, to do really anything, you got to get to the kidnapping first because he's got to get her in the car first. Why isn't that an inference that the jury could potentially draw?
Because it's not a reasonable inference from a wave. We're talking about an inference from the evidence, but you are speculating as to what this wave meant. If I could just direct the court to the Johnson case. And in the Johnson case, especially at this point in time, it's dealing with a wife who wanted to murder her husband. And she specifically said, I want to murder my husband. And so she was buying methamphetamine for the specific purpose to murder her husband. The Supreme Court found that still was not sufficient to amount to her buying this methamphetamine, was not a substantial step to murdering her husband, because even though we know that intent was there, the very act of buying that methamphetamine, there could have been a number of reasons to that act alone. So in that case, the number of reasons to buy the methamphetamine could have been that she was going to take it herself, that she wanted to murder her husband, that she was going to sell it. There was a number of things to the act of buying that methamphetamine.
Yeah, but the problem I'm having is almost everything I can think of here goes through the kidnapping box. Like, if he just wants to put her in his car and take her and buy her a lollipop at 7-Eleven, right? That's kidnapping, right? Isn't it?
Yes, but the court is speculating that this wave was for a bad purpose. A person I sometimes sit in my car and wave to a child. And it's not because I want to kidnap the
Not this way
child.
typically, you would do it this way. I mean, it seems like the only innocuous explanation available is he's concerned about a 3-year-old wandering around the park without parental supervision, and he's motioning her over to ask where her mommy and daddy are, or is she okay? I mean, I suppose that's possible.
Perhaps. And that goes into the mix of all the other speculation that we are having about what this wave, this purported wave, means.
'Cause if we assume that there is evidence that it's not speculation, but a reasonable inference of malintent, and are there things short of putting her in the car that he could have intended with the wave that are malintent?
Yes,
What?
to do exactly what he did before. He's getting her attention. He's sitting in his car. He's masturbating. He's trying to get her attention so she looks at him. That's not cool, obviously, right? But you can't jump to the intent that he's going to kidnap this child.
But if all he's trying to do is get her to look at him, to Judge Orm's point, you can do that like this. Hey,
You could.
you don't do that by
You could.
come over here, right? Do you? Or at least the inference could be drawn
Well-
to the other way.
The inference could be the other way. There's also some differing testimony about this wave later on, right? But again, we're assuming that this wave happened. But if you're just doing this and you're not saying anything, you're not getting out of your car to grab the child, you're not doing anything else, you're sitting there and you do this, how is that intent for anything and everything? That could be an intent for everything.
Can I ask just to make sure I understand the record, this case is set for trial on January 13th?
I believe, yes.
Something like that,
Yes.
about 2.5 months from now?
Yes.
Okay. And everybody thinks that's gonna go?
We don't know. You know, the court knows how
You
it works.
never know.
We are set for trial. We have our dates. We don't plan necessarily on moving it unless something happens, so.
All right, and I guess there's a lot to talk about on mootness, but we'll hear from the state first on that, I guess.
Thank you, Your Honor.
Thank you. Ms. Doucette.
May it please the court, Wasong Doucette for the state. The court has been focused on the merits of the bail ruling below based on the detention hearing evidence alone, but as the state has pointed out, that detention ruling has been mooted by the later order that the trial court issued following the preliminary hearing.
So as I read the case law, the question isn't whether the ruling has been mooted. The question is whether the controversy between the parties has been mooted. That's the language that the cases that talk about mootness use. And I guess I'd like to know from the state's perspective how the controversy between the parties about pretrial detention has been mooted here when Mr. Groce remains in pretrial detention, right? These bail cases do get mooted rather frequently,
Yes.
but they generally get mooted by people pleading out in order to get out of jail, or they get mooted by the case resolving somehow, or getting to trial before we can decide it. And if the case gets all the way to trial, then obviously the pre-trial detention issue is mooted. The controversy about pre-trial detention is no longer live. And if there's been a pretrial release in the interim, then pretrial detention is no longer live. But the controversy here about whether he should remain in pre-trial seems to be still live, and I guess I'd like the state's perspective on why you think it isn't, given that he's still in.
It's a live controversy to the extent that he is still in bail. We accept that. The issue is that the ruling that he's being held under is not within this court's jurisdiction, because that order was never appealed. That the time for defendant to have appealed that passed, and he never put the new findings before this court. So there's two things. The order is moot, and the order that is holding defendant, the court doesn't have jurisdiction to look at.
Why is the May 6th order the one that's holding defendant? Why isn't it the April 11th order after the March 22nd hearing, which was, as I see it, sort of the original order? Or why isn't it the June 27th order after they made another renewed motion? Why has the state picked the May 6th order as the one that's operative?
The May 6th order is the operative order because the trial court had new facts based on what was testified to and presented at the preliminary hearing that it did not have when it made its initial ruling. All that new evidence provided more support, as the trial court indicated, to continue detention. And because of that new evidence, essentially the basis for the ruling changed, correct? There was more evidence that now, even if we say, let's say the detention hearing, the initial ruling controls, or the court wants to grant relief on that, it can't, because those facts have changed because of the preliminary hearing evidence. So the court would have to.
I guess, do you have?
I do have a.
Go ahead.
I'm inclined to go with reasoning that ironically is articulated in the state's motion to strike, the second amended notice of appeal. And the language is, if modification is denied, so it comes up for consideration again, if modification is denied, there is no change in status and the old order still controls. And here, the May 6th order of clarification says, I'm denying, modification is denied. Why not then does the April ruling still control exactly as the state articulated in its motion? And the need is simply to supplement the record with the additional evidence. The court made no finding of a substantial change in circumstances.
The substantial change in circumstances in the court's May 6th ruling is the new facts that it was presented with that it didn't have at the initial hearing.
But the court says if the evidence adduced at the preliminary hearing had persuaded the court that a material change in circumstances justified release, then the court would have granted a release. Instead, it clarifies, I'm not granting a release, even after considering this additional evidence. Seems like that's a clear holding that there was no substantial change in circumstance, because if there had been, a release would have been granted.
Not necessarily. The court could have decided that the material change in circumstances warranted release, but in this case, it decided that the change in circumstances meant that the court was going to continue to hold the defendant.
Where would you point to of a finding by the court that there's been a material change in circumstance?
I think based just on the language that you just read, that the court is saying the material change in circumstance doesn't warrant release in this case.
Except that that's not what the court said. It said if the evidence had convinced me that there was a material change. I take your argument to be that if the court hears additional evidence at a preliminary hearing, that as a matter of law, that's a material change of circumstance.
So-
Is that what you're arguing? Is that really what you're arguing?
No.
No.
No,
Okay.
it just happens to be that in this case, the trial court determined, mostly because there was an appeal pending at the time, to address that new evidence.
Well, I guess I don't understand why we can't have an appeal in the same case from two different orders. I mean, they filed a second amended notice of appeal coming up from the June 27th order, and they're also trying to appeal from the original April 11th order. I mean, this happens all the time, where somebody tries to appeal the court's ruling post-trial, and then there's a motion for a new trial, or a motion for reconsideration, or something else, and that comes up to us too, and we're considering the propriety of both of those orders in the same appeal. That we're certainly capable of handling that. The standards are a little different on a motion for new trial, and here the context is the standards are a little different too, because the statute requires on a renewed motion for pretrial release that the movement show a material change in circumstances that you don't have to show originally. So I guess I wonder why we can't consider their challenge both to the original order, talk about substantial evidence and substantial step and substantial danger. We're using the word substantial all over the place, but we could consider their challenge to that order under the standards the statute sets. And then we could also consider their challenge to the denial of the renewed motion under the slightly different standards the statute sets. I guess I need you to help me understand why the state thinks we can't just do that.
The state doesn't think that you can't do that. We just don't think you could do that in this case, because the defendant's motion for, renewing motion for bail or reconsidering bail is what I just said. It's essentially asking reconsideration of the order that he did not appeal in this case. So.
Okay, but why can't we, they're making an appellate challenge to that, why can't we consider it under whatever standards the law sets for those things? Why is that procedurally improper?
Procedurally improper in the sense that it's an entirely different order. The proper procedure at that point would have been to file a new notice of appeal, not an amended notice of appeal, just to insert an order that didn't exist at the time that the original
But
appeal was filed.
Why is that the proper procedure? Why can't they do that in the same case? That's what people do in other cases when they filed a notice of appeal and then a post-trial motion, attorney's fees, whatever, they file an amended notice of appeal and we consider the orders.
The appellate rules allow for certain motions to be filed as part of an amended notice, and the rules do not contemplate there being a motion or an order denying a motion to reconsider as part of that.
But they don't forbid it either, do they? And bail appeals are a strange animal, right? They're one of the, I mean, juvenile appeals maybe are kind of like this, but the appeals out of district court are almost never like this, where something is entitled to be appealed during the run of the case, right? So they've got the statutory right to appeal as of right any bail decision, any pretrial detention decision, and when that gets appealed, the district court generally doesn't stop the criminal case. They don't put it on stay like often happens when we get a 54B appeal or a Rule 5 interlocutory appeal. Oftentimes the district court stays the matter while we consider the appeal. That's not going to happen sort of as a practical matter in the bail context. Mm-hmm. So in this case, both the appellate courts and the district courts are working on the same case at the same time, and that almost never happens. And so I guess I wonder how defendants are supposed to go about this if they can't just continue to file amended notices of appeal in the same case if they file a renewed motion for pretrial release and that gets denied.
Well, there's nothing stopping a defendant from filing a notice of appeal and then moving to consolidate the appeals. It's just keep the issues clear to the court of what is going on. Inserting a later order that didn't exist kind of complicates things, which is sort of what has happened in this case.
I agree with you there. It does complicate things, but I don't think that makes it procedurally improper, or at least I don't see any rule forbidding it. I mean, it seems like the remedy there is just ask for supplemental briefing or supplement the record, or we kind of just got to roll with some of these punches in these bail appeals. We got to handle them fast because they moved out, and seems like the defendants need to have an opportunity to, if they want to, appeal from these subsequent orders as well.
But they do have a right to appeal from the subsequent orders. It's just they would need to file a new notice of appeal directing the court that there's been a new order issued. Otherwise,
Am I
Yeah, and you say that,
understanding?
but I guess I'm asking for chapter and verse as to why that's required.
I don't know off the top of my head, other than my general understanding of how filing an appeal works, and for every new order or issue that a defendant wants to present, it has to file a new notice.
Is my understanding correct that what you're saying is that the May 6th order of clarification in the state's view became a new order of detention based on a new set of evidence? And that order, because the statute says that you can appeal from the order, that order needed to be appealed from, and that what the second amended notice of appeal did was purport to appeal from denial of modifying that that May 6th order. Is that
Correct.
the argument? And that you've got to appeal the order, not the denial of modification of the order. Isn't that the technicality that you're standing on?
No, I mean, I agree that it is, you have to appeal the order that is controlling the detention in the case. The only disagreement I have is that the motion to modify that the court is viewing is actually just a motion to reconsider. All
And so
we know,
you-
other than looking at, sorry,
You view the May 6th order of clarification as the operative order,
correct.
and that a motion to modify that order, you can't appeal from the denial of the modification, you had to appeal from the order itself. Is that what you're saying?
Yes, but
Okay.
the state is characterizing that the later motion is not a motion to modify.
Okay, there's.
Just because we don't know if defendant presented any new facts for the court to consider. If defendant could show us that there were new facts, that ruling actually changed the
You're saying it was
findings
a
of the
motion to
court.
reconsider, not a motion
Yeah,
to
and
modify.
Correct.
these
I
are
know.
good, these are good substantive arguments as to why Judge Blanche was correct as to deny that motion. But I don't know that they moot our consideration of the April, or their challenge to the April 11th order, right? Those two things can both be true, can't they?
No, because the later orders moot out the first detention order. The detention order is not operative anymore. It has no controlling effect on the defendant. So if the court wants to grant relief on that, defendant is still being held under the later order, and the court can't consider the facts that even if the trial court may have messed up the first time, maybe this new evidence at the preliminary hearing cures all that. So the defendant could still be held, or would still be held under the controlling order, the later order.
All right, I mean, I'd like to hear
On
from
the
the state on the
substance.
merits, and I know we're running low here. The pressure point here seems to be a substantial step of, intent to, how do you say this? Is there evidence of intent to take a substantial step toward attempted child kidnapping? And I'd just like to hear the state's
Yeah.
argument on that point.
I think the starting point for this is to examine the totality of the evidence and whether it strongly corroborates the intent to kidnap here, which is merely seize, confine, detain a child without the parent's consent. And here we have a lot of evidence that shows that there is an intent to put hands on the child or get the child closer to him to the extent that he can kind of control movement. So we have defendant being a registered child sex offender with a previous conviction. We know that he's in a protected area, which is adjacent to a playground. He's backed his car into a parking space. He is sitting in his car with the door open with one leg out, sort of indicating quick movement of any sort if perhaps the child got closer. Those are all inferences to be drawn from that. We know that he's calling the girl over to him Defendant disputes that there was any actual communication, but at the bail, or the detention hearing, there was evidence of defendant saying, "Come here, girl," in Spanish. We know that all of that caused enough alarm for these two Samaritans to feel they had to intervene. And then we have the defendant's essential flight from the scene.
To me, the pinch point here is that, and my question is, could all of this evidence point to an intent to do something bad, criminal or not criminal, but malintent, short of kidnapping? And I look at the Johnson case where the wife in that case said, "I want to kill my husband. I want to buy drugs from you to do it." She buys the drugs, and the court says that's still not a substantial, or we still don't know that her intent was to kill her husband because we don't know where the drugs went. There was more than one possible crime that could have happened here. Isn't there more than one possible bad thing that he could have been doing here, short of putting the child in the car?
There is, but the state doesn't need to disprove all the inferences that a jury could come up with. The state's burden is to show substantial evidence that from the evidence, the jury could infer the defendant was trying to kidnap the child.
How would you square that with Johnson then, where Johnson said, we don't have sufficient evidence, where this could have been that she wanted to kill her husband, or it could have been that she wanted to sell the drugs, or it could have been that she used the drugs?
Well,
And here, he could have wanted to put the child in the car. He could have wanted to just get the child closer to masturbate in front of the child. He could have just wanted to get the child over there to talk to a child and feel aroused. We can point, can't we, to more than one possible mal-intent, and we'd have to speculate between them.
It's not speculating, it's drawing reasonable inferences from human experience. And the difference between Johnson and this case is that we have a clear substantial step for what is intent to kidnap. We have here defendant calling over the 3-year-old. That is a substantial step in committing the crime of kidnapping, is to get the victim closer. Does that answer the question?
Perhaps as well as I can think of how to answer it in light of Johnson.
So with that, the state closes with the court does not have jurisdiction to rule on the merits of this case because of mootness, and that the court should dismiss this.
Thank you, Ms. Doucette. Ms. Taliaferro.
Thank you, Your Honor. With regard to the mootness question, procedurally, there is one pretrial detention order in place. When somebody gets arrested, a temporary detention order is put in place until you have your detention hearing. At that detention hearing, the court makes a pretrial detention order. They either release you on conditions, or they hold you without bail, or they hold you with bail, whatever that is. There is one detention order.
And in your view, that's the one that happened after the 2-day over 2 weeks
Yeah.
pretrial detention hearing,
Yeah.
where the court put it on hold for a little while to get the release recommendation report. Then after all that information was in and he could consider, pretrial release conditions, that's the order that holds him.
That is the order that holds him, and the findings supporting that order was that there was substantial evidence, and that there was clear and convincing evidence that he would be dangerous. That is what we are appealing. Nothing thereafter, no opining by the judge, no additional orders that nothing new has changed and hasn't convinced me to change this. Nothing that's happened after has altered this initial, this
And that's
single.
because, you think that's true because the judge found there was no material change in circumstances?
Well, no. I think that's because there were nobody brought it to their attention that there was a material change in circumstances. So the
Well, you
procedurally, the way
did.
this
You,
works.
at the end of the end of the hearing on the motion to quash the bind over, you made the motion orally
Right.
to renew,
Right.
so your point there was what the court heard at the preliminary hearing did change the landscape,
Right.
and it is a material change, and the court
Right.
said, no, it isn't.
Right. And so let me go back two seconds. Nothing, no further orders, that the court hasn't changed its mind, the sua sponte clarification ruling saying, you know, I listened to the preliminary hearing and my mind wasn't changed. That wasn't like a modification. That was, it was still relating back to this one order. The only thing that would change this detention order, this one detention order, is if somebody, and the court is right that I did this later, if somebody says that we believe that there is a material change in circumstances, reconsider this order. That was not done until the preliminary hearing. And my material change in circumstances.
You mean until the motion to quash the
Right.
bind over hearing?
Right, until after the preliminary hearing. And my material change in circumstances was the court barely found probable cause that basically does not amount to substantial evidence. And so I wanted the court to make
Yeah,
that rule.
and you filed a second amended notice of appeal telling us you wanted to appeal that order too.
Right.
So in your view, you're appealing two different orders, right?
Well.
I mean, that's what
Yeah,
you told us.
Yes. But I didn't quite know procedurally how to deal with that. So I filed an amended notice of appeal, and I also said, you know, if this and I moved to kind of in that real weird appellate thing. I said, if this really isn't an amended notice of appeal, then this is really an appeal because we are in this amorphous, we don't know what to do with these bail rulings, so consolidate them. But
You filed it in the same appellate case number, so there's nothing to consolidate.
I filed it, I filed my notice of appeal in the district court. I didn't necessarily put on an appeal number, and I may have, and if I
Oh.
did, that's my fault. But then the district court probably just sent that to the appellate court.
Yeah,
under
so
this
that's what
number.
happened here procedurally, and that notice of appeal got docketed in the same case. I don't know if that was your doing or our clerk's doing, but in terms of, we don't have anything to consolidate because there
No, right.
aren't two appeals here. There's just one appellate case
Because
number.
nobody really knows what to do with these amorphous things.
It seems to me that there could be two things that trigger there being a new order that needs a new notice of appeal. It seems like one way to approach it would be to say, there's no new order unless you change the status of the defendant. And that seems to be what you're arguing.
And I think it's more easily seen in the sense when the pretrial detention order allows the client released, right? So they're out doing their thing, and then they violate a condition of release, or they violate a protective order or something. Then the material change in circumstances is brought by the state to say, okay, he's violated this,
Yeah.
put him back
Well, see,
into
that
custody.
highlights, in my mind, the two ways that we could approach this. Either you have no new order and therefore don't need a new notice of appeal unless there's a change in the defendant's status, or if you have a finding of a material change in circumstance, then whatever order comes out of evaluating the new circumstance, even if that's not a change in status. Here, if the order had been, we've had the preliminary hearing, the bind over hearing, and I find there is a material change because we've got different evidence, but even in light of that, I'm still ordering detention. That could be a new order based on a new set of evidence and a different way of viewing it, and then you'd need a notice of appeal from that order.
And I agree with that, but it's not just a change in status, because you have the one detention order unless there is a material change of some sort.
Yeah,
So you would say it's the material change and not the change in
And
status?
whether the court finds a material change, whether a party says there's a material change.
But even if the court doesn't find a material change, that's still got to be appealable somehow, right?
Right,
I can
right.
envision a situation where either the state or the
Absolutely.
defense would want to appeal a subsequent detention order where the court didn't find a material change.
Absolutely.
But there actually was one. right?
And I would
so-
say that's this case.
Well, maybe, I mean, that's your argument, but it seems to me, in that case, the judge could have very well have been right with the initial detention order. Then something comes along and changes the landscape.
Yep.
And the judge says, no, I don't think that's a change. And so that's the order that's got to be appealable in that case, because you know, your real challenge would be to the judge's finding that there was no material
Right.
change. So both of these things have got to be appealable in the same case somehow.
Right.
And we've got to figure out a way to make them manageable fast, because these things get mooted out. That's the challenge that I think we're all kind of struggling with here, is how to do that. And I know there hasn't been a ton of guidance on this because most of these get mooted out.
Right, I agree.
So do we have your input on how that should go then? I think, right? Anything else you want to add on that?
No, I mean, I just think that the court's right, that I know that there's no legislation or anything right now, but it would seem that there could be some rule or something to say that anything dealing with detention, the court hears, you put it all into this single appeal. Because you're dealing with the issues anyway. You can do supplemental briefing, you can do whatever, but it's not a matter of, you appealed from this ruling, but you didn't appeal from this ruling, so gotcha, you screwed up because the court here said he didn't find anything different, so you don't have jurisdiction. That can't be. We have appealed the detention, and any further rulings dealing with that detention should just be consumed in this single appeal for that very reason that it has to be expedited and it has to be done quickly because it does get mooted out. And you know, 2, 3, 4, 5, 6 months sitting in custody when you believe you are wrongfully being held in custody, that's a long time. And yes, we can go to trial later and perhaps we will win at trial, but that person has still sat in custody on what we believe an improper basis. And so it does have to be quick, and it can't be, you didn't, talk about this order, so case over, dismiss it, you guys don't have jurisdiction.
And I apologize to stay in the little weeds on this, but it seems like the crux of the disagreement is that you view your final motion for modification, from which your second notice of appeal was taken, as a motion for modification
Yes.
that was denied,
Yes,
whereas the state views that as a motion for reconsideration, and that because you didn't point to new evidence that the court hadn't already considered, we can't really call it a motion for modification.
and I do believe it was a motion for modification, but I think the court, Judge Blanche wanted to, he basically said, I am taking everything at the preliminary hearing in addition to everything I heard before, and he still kind of combined everything together anyway. So, I filed a new notice of appeal out of an abundance of caution, but I don't think necessarily I needed to in this case. But I think where the rub is that the state doesn't want or has indicated that I can't supplement the record with that preliminary hearing information for the court's consideration of the mootness information. So everything at the preliminary hearing from our view was even better than what happened at the detention hearing. So Judge Blanche's indication on my motion to modify or reconsider or whatever you want to call it, we still believe is wrong because it still didn't show substantial evidence. And nobody has ever talked about once, and I asked the court not to forget about the second prong, the court still has to find clear and convincing evidence that Mr. Groce is a danger to society and that there's no conditions. And we believe that that was wrong as well. So, and this new reconsideration or motion to modify didn't deal with that prong in any event at all. So I think I've rambled and I didn't even answer your questions.
No, I think you did, and I had one more. You'd agree that if you hadn't supplemented the record, then we would have a mootness problem, or a problem that we wouldn't have before us all that the court ended up considering in keeping the defendant detained.
I don't believe it's
It's
quite
probably not
frankly,
mootness.
I quite frankly don't believe it's a mootness issue because I don't think anything that came after
Would it be
mooted.
an adequacy of the record?
It might have been an inadequacy of the record thing, but the problem is that the state argued because there was an inadequate record, it was moot. But if the state's gonna argue it's moot, then they need to put in the evidence showing why it's moot. And I forgot about this until I started preparing, but they put in some information from the preliminary hearing. The state attached some of that information, the state exhibits. The state didn't attach, at least to their 10C memo, they attached some exhibits from the preliminary hearing, all the state exhibits. They didn't attach anything from the defense exhibits from the preliminary hearing, and they didn't attach the transcripts to show their argument that it was somehow moot. So I don't think it's a mootness argument, but I think I argued in reply, they can't have it both ways. If it's gonna be a mootness argument, then they need to put in the evidence to show it was moot. And if the court considers the preliminary hearing stuff, then it solidifies that it's not moot, because the preliminary hearing evidence was even better for us. And I see my time is very much out.
We kept you.
Thank you very much.
Thank you both for your briefing and your argument today. We are past the time for our next matter, but we will go ahead and take a brief recess to allow council to switch places. We'll get out an opinion on the Groce matter as soon as we can. Thank you.